Good morning, ladies and gentlemen, and welcome to the last in our current series of free and exclusive webinars in partnership with Carson McDowell Solicitors. My name is David Fletcher, and I am the chair of the Construction Professionals Council Northern Ireland. This morning's webinar will cover professional appointments. As we all know, the negotiation of the contractual terms and conditions in professional appointment can often seem like a potential minefield. Carson McDowell's specialist construction team, made up of Doug Dale, Rebecca Ferguson, Gavin Kerr, and Stuart Murphy, will take us through a number of issues that commonly arise and give guidance on how to deal with them. The presentation is due to take approximately 50 minutes, with 10 minutes for question and answers at the end. Please use the chat function at the side of the presentation to log any queries that you may have, and we will try to get these at the end of the presentation. I will hand over to John Dugdale to start the presentation, but what I would say is that we will look to do further webinar series after the summer period. So we will send out a recording of this presentation, and we'd ask for you to respond to that, the email that's provided in that email, and give us further suggestions for future webinars that we can try and cover for you. So without further ado, I'll hand over to John and Rebecca Ferguson, obviously, to start the presentation. Thanks very much.
Thank you, David, and thank you to the CPC for the opportunity to speak with you this morning about professional appointments. As David said, this is the fourth and final webinar in the second series of webinars that we've delivered in conjunction with CPC. Obviously, the webinar format was born out of the COVID lockdowns, so potentially after the summer we might like to change up the format. Be good to see some people in person rather than looking at myself and David only when delivering these. But generally it's been a great experience for us to engage with the CPC's members and try and focus in on the issues that primarily are affecting professional consultants. From my experience, appointments are probably second only to collateral warranties and things that consultants just love about their job. So we really do appreciate you taking the time to join us this morning. Whilst a lot of time is rightfully spent on poring over the terms of collateral warranties, appointments sometimes don't receive the same level of attention. However, I suppose the clue is in the name. A collateral warranty is collateral to a professional appointment. Warranty will refer back to the appointment. So the appointment's just as, if not more so, important than the collateral warranty. This morning, we're going to look at how professionals are usually appointed for not just construction, but engineering projects. I'll look at some of the commonly used standard forms before my colleagues will look at some of the key terms relevant to professionals and some recent court judgments that are worth knowing about. Our goal is that after this webinar, you'll understand some of the key issues to consider the next time an appointment comes across your desk, what to look out for, or even if you're tasked with preparing a professional appointment for a client. All being well, as David said, we'll have some time for questions at the end. Please do send them in via the chat function. For the Shire members of the audience, you can send them direct to any one of us rather than the whole group, so you can get some confidentiality and we won't name any names. So getting into professional appointments, then the first thing I want to consider probably sounds almost too simple to spend any time on, but who is going to be appointing you? Who will your client be? Some very simple things to get right at the outset, including having the correct name of your client. You'd probably be surprised by how often we encounter clients who don't know or don't have the correct or precise name of the person or business that they're dealing with. And I know that can be more complicated, particularly if your point of contact has an interest in several businesses, or there's a new company to be set up for a particular project. But it's something that's definitely worth clarifying at the outset. You also need to know how your clients are going to trade. Is it a sole trader or a partnership or a limited company? If you have that information and can do some due diligence at the outset, it's very worthwhile, even looking at a limited company's most recent accounts, particularly in a difficult market, having some clarity on who's liable to pay you is a crucial point. The answer to who your client is will also be impacted by, amongst other things, how the project is procured. The main feature of what's termed traditional procurement, and apologies if I'm teaching my granny how to suck eggs here, is that the design and construction of the project are kept separate. That is, they're separate design and construction roles carried out by different parties. The employer will generally appoint a building contractor, and separately it will appoint a team of professional consultants. What we have seen is a rise in a tendency for an employer to appoint one lead consultant, with the rest of the design or professional team being appointed as sub-consultants. That leaves the lead consultant as, I suppose, the single point of responsibility for design from the employer's perspective, but also leaves that lead consultant in a position where it not only has to deal with its own appointment and negotiate with its own client or the employer, but also having to appoint each of its sub-consultants and try to do that hopefully on terms that appropriately pass on the risk that it's taking on. But either way, the team of professional consultants designs the project, the contractor constructs the project. There'll be an architect or contract administrator there to administer the building contract. That could be potentially project manager or an engineer on a engineering project, but generally the setups as set on the slide. Things get slightly more complicated under a design and build procurement, where generally a contractor ends up with responsibility for both the design and construction of a project. It may appoint its own specialist designers to carry out design, and the building contract usually confirms that the contractor is responsible for the performance of its subcontractors or consultants. It's common for the employer to appoint the team, the professional team, again at the outset to deal with the development of the initial design. And after this, the employer, the professional consultants and the contractor often enter into innovation agreements to allow the contractor to complete the detailed design of the project with the benefit of the professional team's knowledge. Novation essentially extinguishes one contract between an employer and a consultant and replaces it with another between the contractor and a consultant. And ordinarily at the time of novation, you may also be asked to provide a collateral warranty in favour of the employer, which means you'll have responsibilities to both employer and contractor through construction stage and beyond. We'll not have time to get into what a novation agreement ought to say today, but I would ordinarily expect that if it's proposed that your appointment will be novated on a design and build project, that the form of that novation agreement ought to be agreed at the outset and included as a schedule or appendix to your appointment. That requires early planning and thought about procurement strategy, but provides some certainty for both sides on what they're signing up to. The diagram on that slide shows a usual setup for a design and build procurement prior to construction. I'll move on to the post-novation or during construction setup. But my colleague Rebecca is now going to speak about a recent case in which one of the key issues in a £12 million claim against a professional consultant was which party had appointed it on a particularly complex contractual structure. Rebecca.
Thanks, John. Hi, everyone. So as John said, I'm going to briefly chat about a recent case which looked at the contractual relationship, or probably more appropriately lack thereof, between parties in a construction project. It's the case of Multiplex Construction Europe Limited and Bathgate Realizations, which is a 2021 case. A brief background to the case is that Multiplex was the main contractor in a large construction project. They engaged Bathgate as a subcontractor, and Bathgate then engaged BRM to carry out part of the design works, and they also appointed RMP to provide a Category 3 design check. RMP provided 2 check certificates to Bathgate, And Bathgate then went into administration and an alternative subcontractor was engaged. This new subcontractor discovered defects in the works despite the checks which RMP had completed. So the question for the court here was whether an independent professional consultant, in this case was RMP, which was appointed by a subcontractor who was Bathgate, owed a duty of care and tort to the main contractor who was Multiplex. So despite there being no contract and no direct contractual relationship between Multiplex and RMP, Multiplex alleged that RMP owed it certain duties of care and obligations in respect of the Category 3 check and the certificates which were issued by RMP. And after hearing submissions from all the parties, the judge came to the conclusion that RMP did not owe any duties or obligations to Multiplex in respect of the check design certificates, nor did it provide any warranties to Multiplex. The case went before the court and the judge came to the conclusion that RMP did not owe any duties or obligations to Multiplex in respect of the check design certificates, nor did it provide warranties to Multiplex. The court identified a number of reasons why it reached the decision that it did, but in particular, they found, firstly, that Bathgate had full design responsibility for the subcontract works under the subcontract with Multiplex, and this included responsibility for the design of the works which were found to be defective. Secondly, there was no direct contractual link between RMP and Multiplex in relation to the check or at all. And lastly, then Multiplex was not actually involved in the instruction of RMP. It didn't know what documents had been provided to RMP, and they didn't know under what terms RMP had been engaged. So I suppose the main takeaway from this case is that the conclusion of the court shows that careful consideration needs to be given when drafting the terms of any contract documents, including appointments or reviewing the terms of any appointment that you're going to be a party to in great detail to know exactly what you're getting into. So I'll now pass you back over to John.
Thank you, Rebecca. I suppose what I take from that case is that the certainty of knowing that the consultant had been appointed by the subcontractor as opposed to Multiplex meant that it was able to defend the claim, essentially. There was no collateral warranty in place. That might be something as a professional consultant you'll be asked to provide, whether it's in that case to a main contractor or potentially to an employer if you're on the construction side. But I think that the certainty of knowing which party had appointed it was a key aspect of the defence in that case. Next up, I want to look at some of the various types of professional appointments that we would most commonly see. There are published industry standard appointment documents, which can provide a useful template or starting point for any appointment. As I said, there are numerous of those standard forms of professional appointment currently in print, and I've noted just some of these on the slides. I've tried to keep everyone in the room happy, so architects, engineers, and surveyors are all represented on the next few slides. I want to start off though with the NEC4 professional service contract, which is the NEC4's main contract for the appointment of a professional consultant on a construction or engineering project. It and its predecessor, the NEC3, professional services contract, are the contracts of choice for government when it comes to procuring construction works. So it may well already be familiar to any of you that do work in the public sector. Like most professional appointments, the NEC4 contains a set of terms and conditions setting out the obligations of the parties, but attached to that are various schedules, essentially. The schedules in a professional appointment are usually just as crucial as the terms and conditions and need to be considered carefully. Rebecca will be back a little bit later to talk about a case that obligations arose out of an obligation that was tucked away in what was said to be voluminous schedules. So they do need to be checked. But the schedules within NEC4 professional service contract include a scope, which is the document that sets out much of the key practical detail of the contract, such as the services to be performed. So an adequate scope is essential to the success of any appointment based on a PSC and it's really a key document for you to review. The contract data, another part of the NEC4 sort of makeup of the contract, allows the parties to incorporate additional conditions, often referred to as Z clauses. Those are amendments or additions to the NEC4 terms and conditions and are usually employed to deal with project-specific requirements. They can and often do change the risk profile of a professional service contract. So again, those need to be considered carefully. Contract data also allows the parties to select which of the various payment options provided for in the PSC apply. So again, contract data is completed by the party, so it's important that that is done so that there's clarity about how and when you're going to be paid. The NEC4 also includes what are called X clauses, which cover a number of matters, include that parties often address or agree to address in their professional appointment. They're published by the NEC4, so they're not, like Z clauses, bespoke drafting, but the parties select those clauses as appropriate, and those X clauses include, amongst others, X18, which are limits of liability in favour of the consultant. So if you want those limits to apply, then clause X18 needs to be incorporated into your appointment, and that again goes to completing the contract data appropriately at the outset. And just finally on NEC4, then there is also a professional services short contract, which is a shorter and simpler form of contract, recommended for use on projects that are more straightforward or low risk. So you might consider, well, that's a more appropriate starting point than the longer and more complex management required of a professional service contract. Standard forms are not always limited to just one appointment, no matter who publishes them, but usually comprise several different versions, each of which is suitable for use in different circumstances. For example, the architects, RIBA, their suite of contracts includes a standard, concise and domestic form. The standard is essentially the flagship form of professional appointment intended for use on a business or public sector commercial project. The concise form, as you might imagine, is for use on simpler, non-complex projects, but again, where the client is a business or public authority. Domestic form then intended for use on a domestic project, usually work on a client's own home. Just looking at some of the aspects of a RIBA standard form appointment, it does include 4 limitations of liability in favour of the consultant, including a cap at the required level of PI insurance and a net contribution clause. My colleague Gavin is going to be back to look at net contribution clauses in more detail, but as a general rule, they're often resisted by clients but coveted by consultants and their insurers, so it can be a contentious point in any negotiation. Stuart's also going to look at assignment later on, but a point that regularly comes up for us is the ability of a client to assign the benefit of an appointment, most usually to a funder. RIBA doesn't allow for assignment without the consultant's consent. And as I say, assignment can be a requirement of a funder on a development project, so a client is usually unlikely to want to take any risks with its ability to meet a funder's requirements. So again, assignment's one of the issues that we regularly grapple with. And finally on RIBA, its copyright license in favour of the client is subject to payment of all fees. Well, it might seem like a non-contentious point. In our experience, that's sort of a caveat to a copyright license is not usually acceptable to developers, clients or funders, and doesn't represent, I suppose, general industry practice when it comes to negotiated documents. Next up then, we want to look at the ACE suite. The flagship appointment here is the professional service appointment. I think the latest is 2017 edition. There's also a sub-consultancy agreement and a short form of agreement. Sub-consultancy agreement might be particularly appropriate for those of you that act in that lead consultant role and have to appoint various other consultants. In terms of structure, ACE appointments are supplemented by various schedules of service, which are tailored to specific roles. So, for example, mechanical or electrical engineering roles or civil and structural engineering roles. In practice, I think the ACE agreements are most likely to be used if they're proposed by the professional consultant, usually the engineer. On larger commercial projects, our experience is that the client routinely provides the first draft of the professional appointment, and sometimes this may be based on a standard form or an amended standard form, but the most common approach is to use a bespoke form, and I'll come back to those. On the terms in an ACE agreement, I suppose the total potential liability on any appointment that a client or a consultant is willing to accept and a client is willing to agree to depends on the parties, the project, and negotiation leverage. But in the ACE professional appointment, there is an overall cap on liability at 10 times the fee payable to the consultant. That's obviously beneficial for a consultant, but whether this is acceptable is going to depend on the project, the parties, and of course what that fee is. There's also exclusions in relation to various types of loss, including loss of business or loss of profits. And again, that net contribution clause comes up. On previous versions of the ACE agreement, the client's copyright license could be revoked in the event of non-payment. But as I said, that's generally an issue for clients, and the 2017 edition doesn't include that wording. So ACE, I suppose, is more in line with what we would see as market practice on copyright license. On assignment, though, there again is that prohibition on assignment without the consultant's consent. So that's probably one that there will be some negotiation over. And then finally, on standard forms, the RICS form of appointment, the flagship form is the standard form of consultant's appointment. There is also a short form again. And again, the RICS appointments are supplemented by various schedules of services, one for quantity surveying, employer's agent, and I think a project manager services as well. Looking at some of the contentious provisions again, the assignment provision in RICS appointment probably more in line with what we would see as market practice. Assignment to a funder is allowed, assignment between group companies is allowed, and I think 2 other assignments without the consent of the consultant. So a much broader position than either the RIBA or ACE appointment. On copyright, that ability to suspend or revoke the license if fees are not paid is there. There's no limitation on liability in respect of loss of profits, for example, but there is a cap on liability at the level of PI insurance and a net contribution clause. For any different level of cap to apply, the appendix for the RICS appointment would need to be completed. But again, the appendix is a document that ought to be reviewed at the start. It forms part of the RICS appointment, and to show whether or not that net contribution applies or what the level of cap is, needs to be given proper consideration. That was intentionally a whistle-stop tour. I'm probably running out of time for my colleagues here, but standard forms are intended to simplify the process of appointing a professional consultant, removing the need to negotiate from a blank piece of paper. They're also intended to, I suppose, strike a fair balance between client and consultant. There's no form that's universally accepted as throughout the construction industry, and that's partly because it's probably impossible to strike a universally fair balance between the interests of the consultant and the client, and partly because it's impossible to cater for every eventuality that may need to be catered for in an appointment on a particular project. There's also, without naming any names or giving any credence to it, a perception that the standard forms produced by professional bodies tend to favour the professionals over a client. That's usually where a bespoke form is drafted, both to suit the particular needs of a project, but also, as I say, try and cover off the particular requirements of a client for a project. That's usually where the poor lawyers get the blame, but there are good reasons for the use of bespoke appointments. They are usually drafted with a specific project in mind and can be tailored to suit individual circumstances. The downside, I suppose, is that it usually costs more and takes longer than using a standard form, which is available off the shelf. So we usually only see it on larger projects. As a general rule, and this goes for standard forms too, neither party should accept a form of appointment without first considering whether it meets your needs and is appropriate in the context of the project. If necessary, either party can suggest amendments or propose an alternative form, and parties often do negotiate amendments even to standard forms, especially on larger projects. The earlier that's done, the better, so that there's certainty on the side of both parties and you can focus on delivering a project. From a lawyer's perspective, invariably having a clear written professional appointment that gives detailed consideration to allocation of risk is preferable to a verbal agreement, but it's worth noting that a verbal agreement can be enforceable. Not all appointments are in writing. The legislation that governs adjudication and payment in construction contracts in Northern Ireland applies to verbal contracts just as much as written appointments. Lastly, for me, then, I'm going to touch briefly on a question I get asked regularly. And it's in relation to limitation periods. It's a limitation period is often linked to the length of time that you're required to maintain professional indemnity insurance. So it's coming up more and more. And a limitation period is the time frame in which court proceedings or arbitration proceedings ought to be started. If a claim isn't brought within the time period, then it will give you a complete defence to any claim. In general terms, if an appointment's executed as a deed, the liability of you as a consultant for a breach of that appointment will be for 12 years after practical completion. Say deed, you might also hear that referred to as under seal. If your appointment is signed underhand, it's not a deed, it's a simple contract, your liability is going to be for 6 years after practical completion. You ought to know if you're signing a deed, there'll be some execution formalities. If you're a limited company, it'll have to be signed by a director. That signature will have to be witnessed. So there ought to be no surprises that the appointment itself should reference the fact that it will be a deed. Apologies for rushing there towards the end. I know I've gone over my allotted time, but I'll hand you over to Gavin now to take forward on standards of care.
Thanks, John. As John said, I'm going to be talking about the standard of care, which is probably one of the most negotiated or sort of hotly contested topics in relation to professional consultants appointments. The standard of care is essentially the degree of care and caution that a professional consultant must exercise under his professional appointment. There are essentially two types of standard of care. One's fitness for purpose and the other is reasonable skill and care. It's rare for a professional appointment to impose a fitness for purpose obligation. A duty of reasonable skill and care can be implied into the professional appointment by virtue of statute. However, parties usually agree and set out an express standard of care to avoid any confusion. Fitness for purpose means that when completed, the project will be fit for its intended use. It's a high standard because professional consultant effectively guarantees that its design will be suitable for that intended use. For example, an architect appointed to design a primary school will be in breach of a fitness for purpose obligation if its design isn't capable of use as a primary school. Reasonable skill and care is a lower standard. It means that the consultant agrees to use reasonable skill and care in performing the services. The consultant can avoid liability even if its design is not suitable for its intended use. And using the example, the architect's only in breach of such an obligation if it fails to act with reasonable skill and care. There's no universally accepted wording for a reasonable skill and care clause. You can see set out on the slide are some of the express standards of care included in the standard form appointments. And also a usual standard of care, which is included in bespoke appointments. So why does it matter as to the standard of care? A reason why the distinction between the two levels of responsibility is so contentious is because most professional PI policies will cover the consultant only in the event of a claim arising out of the consultant's professional negligence, i.e. a failure to exercise reasonable skill and care. This leaves the consultant uninsured against a contractual claim for breach of fitness for purpose obligation, where a defect arises and no allegations of negligence are made. The policy is unlikely to respond to the claim, and insurers may refuse to pay costs associated with the defence of the claim. Further, not only do most professional indemnity policies generally expressly exclude a fitness for purpose risk, since it's difficult to quantify this risk in respect of both probability of occurrence and magnitude of loss. Some PI policies may even be completely invalidated if a consultant has agreed to any fitness for purpose obligations within an appointment. Care also needs to be taken in relation to the inclusion of a fitness for purpose obligation by stealth, without use of the actual words fitness for purpose, and for matters outside the consultant's scope. A common way for this to be slipped in as a requirement is for the consultant to warrant that the completed design shall comply with the client's requirements and or any performance specification. This type of wording commonly follows immediately after a reasonable skill and care obligation, which may lull the consultant into a false sense of security that it's only being required to carry out the services with reasonable skill and care. This type of amended wording has obvious advantages from a client's point of view. It has the same power and effect of a fitness for purpose clause without having to effectively shout about it. But from a consultant's point of view, it needs to be checked and looked at, and also it means that a consultant may be liable to a fitness for purpose obligation without having been expressly set out. So even if a professional appointment contains a reasonable skill and care clause, the professional consultant may still be subject to some absolute obligations. For example, a consultant also has overriding statutory duties, regardless of whether they're set out in the appointment. Examples of these include, and it's set out on the slide, an obligation to ensure that a completed dwelling will be fit for habitation. That's under Section 1 of the Defective Premises Northern Ireland Order, and an obligation to comply with the CDM regulations. Where the duty of reasonable skill and care relates only to the performance of the services, then absolute obligations may still exist elsewhere in the professional appointment. So outside the services, for example, the professional appointment may include an absolute obligation to maintain professional indemnity insurance and an obligation to grant a copyright license to the client. I'm going to pass you over to Rebecca now, who's going to talk about a Supreme Court decision from 2017. Which involved the court resolving conflicting contractual standards in relation to the provision of services.
Thanks, Gavin. So this case is the case of MT Hogarth, who I'll refer to as MT Hitch, and E.ON. The background to the case is that following a competitive tender process, MT Hitch was employed by two companies in the E.ON group to design and install the foundation structures of two offshore wind farms. The tender documents included employers' requirements and specifying technical requirements, which set out that the design of the foundations should ensure a lifetime of 20 years in every aspect without planned replacement, and the choice of structure, materials, and inspection programs should be made accordingly. The technical requirements also required MT Hitch to prepare the design in accordance with a document known as J101, and this was an international standard for the design of offshore wind turbines. The foundation structures of both wind farms failed shortly after completion, and this was due to an error in the J101 standard, which was interestingly subsequently revised by its publisher. The parties worked together to find a practical solution to the problem, and a scheme of remedial works was developed and carried out to a cost of 26 million. The question that arose then was who should actually be paying this cost. And the case, as Gavin said, went all the way to the Supreme Court, and the primary issue for the court was whether MT Hitch was liable to pay that cost. And the key to this answer was to determine if MT Hitch was in breach of a contractual obligation to ensure this lifetime of 20 years, even though it had used due care and professional care, adhered to good industry practice, and complied with the J101 standard. So NTH argued that, firstly, since the owners, E.ON, had specified that the J101 should be used, they're responsible for the unfortunate consequences of compliance with it. However, on the other hand, E.ON argued that the contract went further than this. They said that it contained provisions that required NTH to go further than simply comply with the J101. NTH also argued that an obligation found in the technical requirements in long, diffuse, and multi-authored tender documents was too slender a thread on which to hang a liability to warrant that the foundations would survive for 20 years. The Supreme Court concluded that the technical requirements were clear in imposing a duty on NTH, which involves the foundations having a lifetime of 20 years. That duty wasn't inconsistent with the other terms of the contract and prevailed over the requirements to comply with the J101 and use reasonable skill and care in the design of the foundations. So the judgment in which the requirement for a 20-year design life, as John mentioned earlier, was tucked away in the technical requirements rather than front and center in the contract terms, provides a stark reminder of the need to carefully consider all contract documents in their entirety. So I'll now pass you back over to Gavin, who's going to chat about collateral warranties.
Thanks, Rebecca, for the summary of that case. And I think that just sort of shows that you need to check the entirety of the contract to make sure that you're not exposing yourself to any fitness for purpose obligations, not always front and center in the form of appointment as would be expected. Just moving now on to collateral warranties, which usually the form of appointment will contain the form of collateral warranty or forms of collateral warranty that the consultant will be required to execute in favour of parties interested in the project. As we know, the warranty creates a contractual link where there otherwise would not be one, thereby enabling a third party to have a direct contractual relationship with a consultant, and then the third party can then rely upon the undertakings contained in the warranty in order to bring an action and contract against the consultant if there has been a breach. So who may receive a collateral warranty or seek to receive a collateral warranty? Class of beneficiaries may include purchasers, tenants and funders for design and build projects where the contractor is responsible for all of the design, as John spoke about earlier in relation to his methods of procurement. If the consultants are novated to the contractor, the client will also require a collateral warranty, as it will no longer essentially be the employer under the professional appointment once it's been novated. It wouldn't be usual for residential occupiers to obtain collateral warranties, for example, on housing developments, given the number of collateral warranties that would then be sought to be provided. The residential occupiers would normally obtain a warranty from the builder, such as an NHBC or other such warranty, rather than collateral warranties from each of the members of the design team. In negotiating the terms of the professional appointment and the obligations contained therein, the consultant can usually or sometimes seek to limit the number of collateral warranties that it's required to provide, either by including an express number to limit the number of warranties, or by seeking to limit the warranties to the first tenant and the first purchaser in that class of beneficiaries. So moving on then into talking about collateral warranties again, but also into ensuring in relation to the procurement of the collateral warranties. The terms of the collateral warranty will likely include wording such as that included on the slide for the benefit essentially of the client, to provide consequences in the event the consultant does not provide the required collateral warranties. This may be that no further payment is due, or that a portion of the amounts due is withheld until the consultant satisfies its contractual obligations in respect of the provision of collateral warranties. So from the consultant's point of view, it's important to know what you're signing up to essentially, and what you can be faced with if the collateral warranties aren't provided. If part of the design has been sub-consulted by the consultant, then there may be the obligation for sub-consultant collateral warranties to be obtained. And again, the form of such sub-consultant collateral warranties would likely mirror the form of consultant warranties that are required to be provided. In relation to any sub-consultant warranties, it's important for the consultant to have presented and agreed the form of sub-consultant warranty to its sub-consultants before the form is included in the form of professional appointment. The consultant should be careful that the professional appointment does not place obligations on the consultant that it cannot comply with, or that's out of its hands. For example, the provision to third parties of sub-consultant collateral warranties, which, if not provided due to the consultant refusing to execute, for example, could leave the consultant in a position whereby, because it's failed to provide those sub-consultant warranties, then there's no further payments or amounts are payable under the terms of the professional appointment until those contractual obligations in relation to the provision of sub-consultant warranties have been satisfied. So moving on now, in relation to, John spoke about briefly in relation to some of the standard form contracts and also bespoke, which is, again, one of the important parts of the professional appointment is limitations in favour of the consultant. Whilst consultants will have professional indemnity insurance to provide a certain level of cover under professional appointment, the level of cover may not be sufficient to cover all potential claims, particularly on larger projects. For this reason, many consultants try to limit their overall liability in their appointments. Alternatively, they may seek to exclude certain types of liability, such as indirect or consequential loss. The most common ways for a consultant to limit or exclude its liability are set out on the slide and include financial caps and liability. This can often be linked to the same amounts required to be provided under the professional indemnity insurance, and can be drafted so there's a cap in aggregated amount or in each and every claim amount. Clients commonly seek to ensure that the cap amount and basis mirrors that required being provided under the consultant's professional indemnity insurance, and in particular is no lower than the amount of PI insurance required. Financial caps can also be less commonly used, and with reference to the level of fees, it's usually only when a consultant's appointed on a consultant's bespoke terms. There's also can be exclusions of specific types of loss, for example, contamination and asbestos. There also can be a limit of liability to the costs of repair and replacement. This is common in some of the consultant body standard forms, but it's rarely included or agreed to by clients in bespoke appointments. And then there's also net contribution clauses. Net contribution clause is a specific type of limitation whereby it limits the liability of a consultant to adjust an equitable portion of the loss assessed on the basis of certain assumptions. For example, that the other consultants and contractors involved in the design of the works have entered into agreements containing similar provisions. The net contribution clause reverses the common law position of joint and several liability and limits the consultant's potential liability to the client in situations where more than one person is responsible for the innocent party's loss. A net contribution clause takes effect where a consultant is in breach of contract or has committed a tort and is jointly liable with another party involved in the design, construction, or the management of a project to the client for the loss the client has suffered as a result of that breach of contract or tort. In practice, if a construction document or appointment does not include a net contribution clause, a professional consultant may seek a contribution from another party under the Civil Liability Contribution Act. Under the Contribution Act, if a client claims damages from a consultant and the consultant and another party are both liable to the client for the same damage, the professional consultant may claim a contribution towards the damages from the other party. The Northern Ireland courts have agreed and found that that contribution clause is effective. For example, in the case of Radius Housing Association versus JMP Architects, which was a case in 2018 involving an architect that sought to rely on a net contribution clause to limit its liability to the employer in circumstances where the contractor was insolvent and the employer was seeking to recover 100% of its losses from the architect. Although net contribution clauses are often included in standard form professional appointments, such as those published by the ACE, REBA and the RICS, as John was talking about earlier, such clauses are commonly rejected by clients and particularly funders. From previously speaking about collateral warranties, it also be advised that consultants seek to include a no greater liability and equivalent rights of defence clauses in the forms of collateral warranty. This means that under the collateral warranties, the consultant would not be exposed to any greater liability than that under the appointment and may use any of the wording contained in the underlying appointment or any defence which would have arisen as against the original contracting party, the client, to defend a claim under the warranty, except usually any rights of set-off or counterclaim. I'm now going to pass you over to my colleague, Stuart Murphy. He's going to speak in relation to the copyright.
Thanks, Gavin, and good morning, everybody. You please know I'm not going to do 10 minutes just on copyright. I'm going to have a look at some more of the key clauses in appointments, and in particular give some brief thoughts on the types of issues that you might want to be aware of and consider when you're looking at those clauses. Starting with copyright, and obviously this is of importance to anybody who is carrying out design work, in particular under their appointment. The first thing to be aware of is that just because somebody is paying you to carry out design work doesn't automatically mean that they then own the copyright in the design that you produce. Unless the appointment actually transfers ownership to the client, then the more normal arrangement is like the slide that's on the screen, or the extract of the clause that's on the screen there. The more normal arrangement is that ownership remains with the consultant, but the consultant gives a permanent and free license to the client to use that design. John's already mentioned one thing to think about in relation to this, which is whether that license is to be made subject to the payment of your fees, or whether it's a license that applies in any event. And I think John said that the REBA form does make it subject to fees, but certainly our experience is that most clients will amend that provision or will not include it in their bespoke form of appointment, because they want the ability to make use of the design, regardless of any arguments there might be about fees. The other contentious issue here sometimes is in relation to using a design for future extensions of a project, where obviously the consultant's concern will be that basically his design that he's been paid for once isn't then being replicated on future projects that he's not getting paid for. But equally, clients will be concerned that if they do at some future point want to extend their building or their project, that they will at least have access to the design during that extension. So quite often what the compromise there is that whilst the client can use the design to inform the extension, they're not able simply then to replicate the design in the future extension. They don't get to use the copyright for the future extension. But really what it's one of the things to look at and see what's actually dealt with in your clause. Moving on then, and everybody's favorite topic, professional indemnity insurance. It's certainly, I think, a hot topic of the moment, because increasingly the insurance market is becoming more restrictive about both what it will and won't insure, and also the cost of insuring. But there's a number of issues to be thought about here. Obviously, the headline rate of insurance, or the headline level of insurance that you're required to maintain, is one issue. But that is that's not certainly not the only issue. And as well as looking at the figure £10 million in the example on the slide, it's also important to know whether that's on an each and every claim basis. So the example of the clause there in blue is on an each and every claim basis, or whether it's an amount in the aggregate. and the key thing is to make sure that you're not signing up to a level of insurance on a basis of insurance that A, you don't currently have, and B, you're not prepared to pay for going forward. These are quite long running obligations, maintaining PI insurance. John already talked about the difference between simple contracts and contracts under deed and the 6 or 12-year liability period. Your requirement to maintain PI insurance will be tied to that, and it'll either be 6 or 12 years, depending on whether or not the appointment is a deed. That's fairly standard, but what's less standard is when that 6 or 12-year period starts to run, and that's something you need to watch out for, because there can be quite significant differences from one appointment to another. Some tie it to when the works are practically complete, some tie it to the end of the rectification period or their defect state, and others tie it to when your services under the appointment come to an end, which, depending on what you're doing, could be earlier or later. You know, so if you're in a involved in any sort of final account process, then that could be even later than the defect state. But the key thing is just to be aware of what the obligation is and how long that's going to run. And the other thing to mention is, and it's a misconception that we come across sometimes, which is that just because your obligation to maintain PI insurance is limited to a certain amount, that doesn't of itself mean that your liability is limited to that amount. Absent the sort of limitation clauses that Gavin was talking about, simply because, for example, your liability is limited to, or your liability to maintain PI insurance is limited to £10 million, were something truly disastrous to happen and a loss be incurred of more than that, then you would still be liable, if it was your fault, for the balance over and above what you might be insured for. So don't assume that the level of PI insurance is a cap on your liability. And that's why it's also important to look at the sort of issues that Gavin was raising on that. Moving on to the next slide then. Really, this is an issue around the rates and the premiums to be paid for insurance. We all know that the cost of insurance is going through the roof. And so having a clause that says that your obligation to maintain insurance is only to the extent that it's available at commercially reasonable rates is a wise precaution. And then if you have that sort of clause, then you will often also see this sort of provision, which then says that if it becomes unavailable at reasonably commercial rates, then the parties need to get together and decide how they're going to move forward, taking account of that. Okay, moving on to the next slide, then John talked a little bit about assignment and novation. So I don't want to spend too long on these. I think it's important, though, to understand the difference between the two. Assignment is a process by which only the benefit of an appointment can be transferred to a third party. So, for example, that will give a third party the right to have the services performed under the appointment, will enable them to enforce the terms of the appointment, but won't necessarily or won't give them the obligation to pay the consultant. That obligation on an assignment would remain with the original client. The difference with novation is that, as John said, it involves the coming to an end of the original contract and the creation of a new contract with the new parties. And it enables both the benefit and the burden of the appointment to pass to the new client. Most commonly seen in a construction context on design and build projects, as I'm sure you know, where the consultants appointed by the client originally, and then when the design and build contractors engaged, novated across to that contractor. In order to achieve a novation, it involves an agreement entered into by all three parties: the original client, the consultant, and the new contractor. Whereas assignment can be done unilaterally by the client and without involving the consultant. But quite often, and it's one thing to check in your appointment, if novation is anticipated, there will usually be an obligation in the appointment requiring you to agree to a novation at the appropriate time. And the terms of that novation you need to look at to make sure that you're happy with that when you're entering into the appointment and not leaving it until you get to the time for novation. Moving on then, the key issue around assignment is likely to be how many times a client can assign the benefit of the appointment without having to get the consultant's consent. Traditionally, the sort of market position on that was allowing 2 occasions for assignment. My experience, that's maybe coming under a little bit of attack, and consultants are pushing back on that more often now, and so it's not uncommon to see fewer than 2 occasions being agreed to. But one thing to think about here is that some types of assignment are often carved out of the number of assignments allowed. So assignment on security to a funder or intra-group assignments are quite often don't count towards the numbers, so they can be assignments over and above the 1 or 2 other occasions permitted without consent. Moving on then, suspension and termination. I know our time is short, so I don't really want to say more here, other than it's important to know when you can suspend, in what circumstances suspension is possible, and also what grounds for termination there may be. Chances are, certainly as far as termination is concerned, there will be more opportunities in which a client can terminate than the consultant can habitually. But you want to make sure that the client's ability to terminate are not too wide or your own too restricted. And the other key thing to think about here are look at the consequences of either suspension or termination. Basically, who pays and what do they pay in either of those circumstances. And then moving on to the next slide, just finally on dispute resolution, the lawyer's favorite topic, and in my experience, clients' least favorite topic. Basically here, the lesson is that there are a number of options and decisions to be made in terms of what the appropriate dispute resolution mechanism should be. The big one is, do you ultimately end up in arbitration or in the courts through litigation if you can't resolve a dispute? But also, are there intermediate steps, what we call a tiered dispute resolution process, before you get to that final arbitration or litigation? And I just, probably not time to talk in any detail about it this morning, but just to flag up that Greater Glasgow Health Board case. If any of you were at our law review webinar in January, you'll have heard a bit more about that case. But that's one that, among other things, says that if you've got this tiered steps before you can arbitrate or litigate, the court, absent agreement of the parties, is going to require those steps to be taken before you get to arbitration or litigation. So on that point, as I say, the assembled masses have assembled. We'll have a look and see whether there's any questions for us.
Thank you very much, Stuart. I'll quickly go into the questions. The the first one I have there is, if there are standard approved documents, why do clients stroke their solicitors not use them? And I'll throw that open.
I suppose I'll answer that question just by lamenting that the poor lawyers got the blame by implication in it. I tried to cover this off when I looked at the standard appointments. I suppose the short answer, David, is that yes, there are standard form appointments there, and they're very useful templates to have, and yes, can be used on a wide variety of projects, either on their own or with negotiated amendments tailored to suit a particular project. But the reality is that there's no universally accepted form, and we often see clients that want to have a form that is tailored to meet the specific names of their project. So that's why we end up with a bespoke form, or at the very least amendments to any of those standard forms. And when we talked about some of the key issues that we see in negotiation on those standard forms, be it limitations of liability or assignment or copyright licenses, those are things that can be changed, and whether they are changed, and particular limitations of liability, what ends up in there, generally comes around to the client, the consultant, their negotiation leverage, and the risk and scale of the project. So I would say standard forms are used. They're very helpful, but I suppose there's no universally accepted form, and why we see bespoke appointments then is clients try and cover off risk in a way that meets their needs and potentially the needs of a funder or end user, for example, in a bespoke document, or at the very least an amended standard form. It's most certainly not the fault of clients and their solicitors.
Okay, thank you very much, John. Moving quickly on to the next question. Are you finding that clients are taking account of more challenging PI insurance conditions and adjusting their requirements in this respect?
Yeah. Well, I'll take that one because I talked about PI a little bit. I think I'd like to sort of bring some good news to the table on this, but I'm not sure I'm able to hugely. I think obviously it's different from client to client, and certain clients who are more experienced in procuring projects, where it's not a one-off, have more of an understanding of the difficulties out there at the moment. I have had one or two clients who've had to kind of rein in their expectations from a PI point of view, where they went out to tender for a project with certain levels of PI, and nobody tendered for it because nobody could meet the PI requirements. And then so they had to sort of readjust and retender. But I have to say, it's there's probably an education job to be done for clients, because I don't know that most clients do really understand, particularly if they're not professionals themselves, what the market for PI cover is actually like at the moment.
Okay, yeah, no, absolutely, I agree with that. So just I'm conscious of the time here, so I'll quickly move on to the next one. Is there any way of getting out of an appointment if the express termination provisions are not applicable?
It's probably me again, because I talked about termination a little bit. Basically, the basic message is that if you don't have a contractual right to terminate, so if whatever is giving you the desire to get out of your contract doesn't fall under the contractual termination provisions, then it's very difficult to get out, simply because the client may be in breach of the appointment is not in itself a ground for termination. The only sort of non-contractual basis for termination is essentially what the lawyers call a repudiatory breach of contract. And what that essentially means is a very serious breach of contract that goes to the root of the contract and is so serious that it's essentially the client showing an intention no longer to be bound by the terms of the contract. And if that very serious type of breach occurs, then that can give rise to termination as a result of it. But absent something as serious as that, you're basically left to rely on the contractual termination provisions, which is why it's important to look at them up front before you sign up to the appointment.
Okay. Yeah. No, thank you.
Probably, David, just adding on from what Stuart said there about repudiatory breach. If a client or a consultant is looking to terminate for repudiatory breach, it has to be considered very carefully. And if there isn't a justifiable repudiatory breach on the part of the other side, then the consultant or the party purported to terminate could itself be in repudiatory breach and then have to pay damages to the other side for its action. So it's just needs to be carefully considered if that's the termination that's sought to be going down.
The risk of doing a sales pitch, it's definitely one that you'd want to take advice on before going down that route, because it's a bit of a minefield.
Okay. No, thank
and
you.
hopefully not no one on this webinar finds themselves in that position in the near future.
Absolutely, yeah. No, thank you. And again, quickly moving on, does the team have a preference between arbitration or litigation for resolving disputes?
I'll kick that one off because I touched on dispute resolution. I think, I mean, it's horses for courses, and they both have pluses and minuses. I think there's a bit of a misconception because arbitration was sort of traditionally the dispute resolution process for the industry, that somehow that was better or cheaper or more specialist. It can be, but often it isn't, is what I would say. And indeed, I've had circumstances where arbitrations work out more expensive than going to court, because with going to court, you essentially get the services of the judge and the courtroom effectively for free, whereas you've got to pay an arbitrator and pay for a venue when you get to an arbitration hearing. I think if you're going to use if you're going to go for arbitration, it certainly pays to think outside the box a little bit about how the arbitration will be conducted, as to whether you can get to what's really at issue more quickly. It does allow you to choose your arbitrator, and you can choose somebody who hopefully will understand the issues. But I think nowadays, whether it's the Northern Ireland Commercial Court, or if you're in England, whether it's the Technology and Construction Court in England, they're well used to dealing with construction disputes, and so they're likely to be as capable to deal with them as arbitrators.
Okay. Yeah. Thank you. And the last question, I believe, is: are there any types of losses that cannot be excluded in the form of appointment?
Probably I'll jump into this one. That's I sort of talked about limitation and exclusion clause, David. You can exclude certain categories of damage, provided the drafting is clear. You can exclude liability for negligence, misrepresentation, and fitness for purposes I spoke about. But there are certain types of liability that you can't exclude, even if you try to by drafting, and these include liability for death or personal injury arising from negligence. That's under the Unfair Contract Terms Act. You can't exclude liability for fraud or fraudulent misrepresentation, and you can't exclude liability for breach of statutory implied terms. For example, if the client's a consumer, such as a residential occupier, you can't include an exclusion that offends consumer protection legislation, such as the satisfactory quality of goods in consumer contracts. That's from the legislation set out in the Consumer Rights Act 2015. So regardless of what your contract says, there's certain types of liability that you can't exclude in the professional appointment.
Thank you very much, Gavin. I'll wrap it up there if that's okay. So just like to thank everyone for joining us this morning. And as we said, this is the last in this current series, and we'll be sending out the recording to everybody who registered. And we'd be grateful if you could respond with any burning issues that you would like to be covered in future webinars, or as well, if you would like the session to be turned to a face-to-face presentation, then please let us know. Unless anybody on the panel has anything else to say.
No, just to reiterate
Yeah.
your thanks, David. I appreciate everyone's patience this morning, bearing with us. I know we're slightly over time, but thank you to the CPC for giving us the opportunity to speak to your members. We've enjoyed it and are more than up for a return to in-person presentations with catering in the future.
Yes, that's it. That's it. No, thank you. And thank you everyone on the panel for a great presentation today. It was very informative, and I'm sure we all appreciated it. Thank you very much indeed.
Thank you, David.
Thanks,
Thank you.
everybody.
Thanks,
Cheers.
everyone.
Thanks, everybody.
Thank you.
Bye now.
Bye.
Bye. Bye.